Hi, welcome to Books to Boardrooms with Dr. Kiran. Today I have the privilege of Ms. Sarah Malik. Ms. Sarah is the CEO at SOL International, a leading law firm here. Sarah has won the Litigator of the Year 2022 at the first GCC Women in Law Awards, and she also received an honorable mention as Law Firm Leader for the Year. So thank you, Sarah.
Thank you.
It's a privilege to have you in my show. Sarah, can you just give a little background about yourself?
Yeah, sure. So I'm Sarah Malik. I'm called to the bar in England and Wales. I've been practicing as a barrister 20 plus years. I know I don't look it, but I have. I practiced in the UK and then I've been in the UAE for the last 9 years. I set up SOL in 2018 as a boutique dispute resolution firm. I saw there was a niche in the market to offer a competitive kind of priced legal outfit with the full kind of transparency and commitment to excellence that you'd get from international lawyers. So I set that up. I'm a barrister by training, not a solicitor, so I'm an advocate. My passion is public speaking, being in the courtroom. I do work worldwide. I train government, I train judiciary on arbitration, on dispute resolution. I've written 2 guides, one on first comparative guide to DFC and UA employment law, and also a guide to GCC arbitration. I'm a visiting lecturer at the University of Middlesex in Dubai, where I run the employment law module for DFC and UA employment law, and also I lecture on international commercial litigation arbitration. I sit on the Middle East Users Council for the Singapore International Arbitration Council. I'm appointed to the Lagos Court of International Arbitrations, and we probably undertake more training both within the UAE and worldwide than probably any other law firm out here. I very much enjoy giving back to the community. I very much enjoy empowering the youth. So yeah, that's just a kind of brief synopsis. In the law firm we have 7 consultants, 7 lawyers. We have external consultants, and we're very proud of how far we've gone and excited to see where we'll go.
I think that's really great. I mean, there's quite a lot of achievements, and I think that's one of the things what you told, giving it back to the society. The purpose of my channel is also to let people hear from people like you and get inspired and motivated, and then see how can they follow, some of the personalities like you. Now, you told about arbitration. I mean, I know, of course, a lot of people know a law firm and what lawyers do, but we hear in this part of the world quite a lot about arbitration. When you buy a property, they say you can go to an arbitrator. So can you just tell me what exactly is arbitration and who is an arbitrator?
Sure. So arbitration is just a private means of sorting a dispute out. So usually if you have a legal dispute, you'll go to court. And the judges are elected by the state. They're paid by the state. You get whichever judge you get, they sort the dispute out. But all of the big ticket disputes and all of the kind of state to state or the multi kind of million disputes and the big construction disputes out here, they all go to a private means of dispute resolution. So what the parties do, if you or I have a contract, we put an arbitration clause in there saying that if there's a problem with the transaction or if there's a problem arising from the contract, we're not going to go to court. We're going to sort this out by arbitration. And that arbitral process usually means that you will elect or nominate, appoint an arbitrator. I will do the same, and those 2 arbitrators appoint a chair. And the people who'll deal with our dispute we have more control over, and they're specialised in the area. So if it's a construction dispute, you might want an engineer who knows about how things were delayed or otherwise. If it's a sugar dispute, you might want somebody who knows about the refinery who's on ground. So the parties get a lot more control of the process. The other great advantage of arbitration is they're confidential proceedings. So they're not reported, and you can imagine that a lot of the big ticket disputes, they don't want that to be reported. And the parties usually agree they are final and binding. So there's no right to appeal in arbitration. We agree that whatever the arbitrator says, we're going to go with, and the only way the losing party can challenge it is if you've got very limited grounds to be able to challenge it in the courts. So it's a private process that isn't undertaken in the court system. The courts supervise the process, and the brilliant thing about arbitration is once you get an award, the New York Convention, it's signed by over 158 countries worldwide, you can enforce that once it's recognized against assets worldwide. Whoever signs up to New York Convention, that country will recognize the award. So arbitration is the best method for business disputes to be solved. It's not all about the law. it comes from the time of trading merchants and majlises and how things are sorted out in the kind of old-fashioned way. So people get together, they get somebody who's an elder or a senior or somebody who knows the area, an arbitrator, and they agree to be bound by what the arbitrator says. So that's basically arbitration.
So that will really help to fast track this business disputes also much faster, because the court can, depending upon the country, it can take it.
Absolutely. So with the court process, as due process, you have the right to appeal, and then it goes to another court, and there's lots and lots of documents that are exchanged, there's disclosure that's very costly. And the arbitral process is a much more kind of refined version of that. It's more streamlined. So you don't have the long delays, or you're not supposed to, even though there's an argument now to be made that arbitration is becoming akin to litigation, and it's taking as long and it has kind of unduly. But the whole point of arbitration, it's supposed to be more expedient, it's supposed to be done quicker. And you don't have all of the discovery or production or disclosure of documents that you'd have in a courtroom, and you're not bound by the steadfast rules in the courtroom. Arbitrations are usually administered under institutions, if they're an institution-led arbitration, and they have their rules of how to do things. But yeah, it's a much more kind of refined, comprehensive version of a courtroom with less stricter rules of a kind of procedure.
But still, the fundamental guiding principle will be the law of the land as well as the contractual terms.
The beauty about arbitration, it's not the law of the land. So the whole point of having arbitration is it transcends borders. We can have an agreement. So for example, I agree to supply you air conditioning. I'm a business based in New York, you're based in France. We agree that the law of the contract is going to be English law. We then say, okay, English law contract, I'm in New York, you're in France. If we fight, if there's a dispute, we're going to go to arbitration, but we're going to go to arbitration in Dubai. And we're going to use UA law, for example, or we can even go to arbitration in Dubai and use a different law. So you can use the law that you want, you can use the seat that you want, you can have a different law of the contract. So the beauty of arbitration is it transcends borders, and it allows us autonomy in how we deal with our dispute. And it also ensures there's no home advantage. So you don't have the French law and I don't have the New York law. And that's why it's an attractive proposition. And the arbitrators, again, can be from anywhere in the world. So it really does allow different areas, different jurisdictions of law to come into play together. And it's the only system that allows both the civil law and the common law to amalgamate. Because either you're in a common law jurisdiction, as we are from the UK, or we have carve-outs here, the ADGM and the DFC, or you're a civil law jurisdiction like the UAE. So it really brings together the fluidity of law, and it transcends all those kind of rules, and it's much easier to get things done because you're not bound by a specific law.
And the advantage, the other way is basically arbitration comes into the picture when there's a conflict, right? And then to dispute, to take the resolution of the conflict, you bring the arbitrator. So, and I have the right, if we both are in two different parties, so I can bring my arbitrator, as you told, from anywhere.
So you get to nominate. You get to basically say, I would like so-and-so, and I get to challenge. And sometimes that's used as a tactic. If I don't want this arbitration to get off the ground, because I know I'm going to go down, I can bring challenges to your arbitrator. And usually the challenges on independence or impartiality. I don't think they've got the right qualification. We've agreed we want somebody who's got 10 years experience as an engineer. This person's only got 8. So I can bring challenges to your nominated arbitrator. And ultimately they're appointed by, for example, if it's the ICC, it's the ICC who'll appoint them. They're the most kind of prestigious institution. If it's, a DIAC, they'll appoint them. So it's appointed by the court or by the institution, but we get to nominate.
So what is the scope of arbitration in UAE? I mean, you've been working in international market, you've been in UK, so what made you come here? So how you see this market?
I think this is a thriving hub. I think what the UAE is doing, it's a relatively new country, but it's made leaps and bounds in what it does generally. In most things, we're always ahead of the game. We are recognized as an arbitrable hub. On the Queen Mary and Westfield survey, which is an international survey and places countries according to kind of stats and their kind of index, we beat some of the more traditional seats. Dubai is seen as an international hub. Remember, wherever you're going to set up business, they need to know that there's a proper recourse if something goes wrong. If you want to attract international business, they need to know that there's a proper functioning court system and a dispute resolution system. Otherwise, why are they going to put all the money and engineer everything into jurisdiction if they don't have protection of rights? So within the UAE, I mean, look, they've done very, very well in terms of putting themselves out there and what they've done in the arbitration world. We have the Federal Arbitration Act now, which was enacted. in the UAE. We didn't have one before. And the scope of arbitration, you can't arbitrate all disputes. There are certain disputes that are left to the state, so things to do with criminality, family law, anything that goes to the economic, social, welfare, moral, political side is always left to the courts. You can't arbitrate a murder, you can't arbitrate, a robbery. So those go against public policy. But all of the big kind of construction disputes, commercial disputes are all capable of arbitration. A lot of parties increasingly prefer arbitration because it's obviously less costly and better in terms of time efficiency than court process. And I think there's a real future for it here. I mean, there's lots of awareness. We have Dubai Arbitration Week, which is coming up in November, and we have people from the worldwide coming, getting involved, and we showcase exactly what we do out here in Dubai. So I think we increasingly have got and getting more and more of a reputation as a proper established arbitral community who are pro-arbitration and allow the arbitral process to run smoothly.
So I think when you told about that, especially some of the exceptions in terms of which does not come under the purview of arbitration. So from a client point of view, the customer point of view, so who are those customers who basically prefer arbitration?
Look, to really go to arbitration, there's the bigger disputes. I mean, there will be the smaller disputes that go to arbitration, but all of the construction disputes go to arbitration. All of the kind of state-to-state disputes will go to arbitration. You've got a problem with an oil rig or a pipeline, it'll go to arbitration. An energy dispute. So the multi-million contracts or the million contracts all go to arbitration. And it's also because those clients don't want the publicity. They want anonymity. They don't want the awards published. They don't want, courts are open processes, whether it's a DIFC or Dubai courts. You can get to know who's in court. You can get to know what's going on. And the arbitral process keeps it confidential. So the clientele are usually local or international, who are doing big ticket contracts, and they need to have an effective remedy. They usually opt for arbitration. We do arbitrations that are smaller in value. You can get smaller ones, but really the cost kind of outweighs what you're trying to get. So the majority of our clients are either local or international, but the dispute, if it disputes, is a very high level, high value dispute.
So they don't want to let who won, who lost, and something like that.
Nothing, because it can affect so many things, and nobody knows what's going on. I mean, you and I don't know so many arbitrations that are going on and who's fighting who and which country is fighting which country.
Can you just throw a short description about what's the whole process, if you can just,
You submit a request for arbitration to the institution. You'll set out your kind of basic claim, and then the other side are kind of notified. An arbitral tribunal is constituted, so they're chosen, nominated, etc. And then you have, akin to like how the courts run, a statement of claim goes in, a defence goes in, a defence and maybe counterclaim, and then the claimant will have an opportunity to put in a reply to the defence and a response to the counterclaim. So the process starts with some legal pleadings that go to and fro. And then they usually set out what we call a procedural hearing, which is a housekeeping exercise. Okay, we're now going to go into an arbitration. How many witnesses do you need? How many do you need? When should we list this for? Do you need expert evidence? Sometimes and often expert evidence is required. So it's akin to a court process, and each institution, if an arbitration is being administered by an institution, again will have a rule book of how many days after I serve the claim do you have to then serve me a response. And if you want an extra time, you have to apply and get an extension. So there is a streamlined process. But that's institutional arbitration. You can also have ad hoc arbitration, where you and I just agree. If we have a dispute, we're going to arbitration, but we're not doing it under an institution. We will agree what the process will be between us, and we might agree the rules, but it's not being administered externally. So it's similar to a court process, and each institution has basically the same steps to allow the parties to plead their case, which ultimately then goes either to a fully contested oral hearing or it'll be in writing.
And so in most of the case, when there's a dispute, maybe sometimes you know that one party is right and other party is wrong.
No, we don't.
Okay. but what I heard is in certain scenario where if two parties are involved and one party is going ahead and filing for arbitration, the other party is not responding.
They can slow down.
In that case, the first party can even appoint an arbitrator for the other party, pay for it.
What a party can't do is be abusive and stop the arbitral process by not getting involved. Okay. So if you and I are in arbitration, you take me on and I decide I'm not going to respond, I'm not going to appoint an arbitrator, let him do what he wants to do, you can go and get a final award without me participating. You're entitled to that. Because otherwise, if I can just run through the arbitral process by not engaging, it's abusive. So the beauty of the arbitration agreement is it's a kind of standalone agreement. Even if our contract falls down, it's null and void, that agreement stands up. You have the right to have everything heard in arbitration, whether I engage or not. And I will be given every opportunity, and the institution or otherwise will say, do you want to get involved? What's your view? But if I don't want to, you can still get an award that you can enforce against me.
And once it's awarded, whatever the final verdict from the arbitration, and that both the party has to anyway follow it, right?
Yeah, what happens is it's interesting because it's a private dispute resolution mechanism that turns public. So to get the award recognised and then enforced, you go to the seat of the court, the seat of the arbitral seat that's administering the arbitration. So if you're hearing it out here and it's onshore, you'll go to Dubai court to have it recognised and enforced. That award goes to the court and then they almost rubber stamp it. And you can only challenge that award on very limited grounds under the New York Convention. So if there's not been due process, you haven't been given sufficient notice or been able to participate, or the arbitrator's supposed to deal with 1, 2, 3, but they've dealt with 1, 2, 3, 4, 5, 6, they've gone beyond their jurisdiction, or they've only dealt with 1, 2, and 5, they've not dealt with 3 and 4. So there's very limited grounds you can challenge the award and say, actually, that award should be null and void, it shouldn't stand up. But it turns from a private mechanism into a public mechanism when that award is then given teeth by it being recognised and enforced by the courts.
So it's as equally good like a verdict from the court versus as a judgment.
That's what you convert it into a judgment.
So, I mean, you are a successful arbitrator. So tell me one thing, what sort of qualification one need to have to be an arbitrator?
You actually don't need qualifications. You need to have an understanding, obviously, of the process. I recommend that you undertake the kind of CIR, the Chartered Institute of Arbitrators. They do various courses. It teaches you about the arbitral process, about how to write an award, and it gives some credibility. But there's arbitrators who've never had any formal training, but they're very good at what they do. But there's not actually an arbitrator's degree or otherwise. There's qualifications, for example, CIR will give you. But my advice would be, if you're interested in the area, get involved. There's always arbitral kind of seminars. We run lots of them. And you'll see in Dubai and in the UAE, there's lots and lots that's going on. Get involved in Dubai Arbitration Week. You need to start having an interest in the area. There's some great texts that are very simple that you can read about. You can also study arbitration, whether it's in a kind of master's or on a LOB. And I think the university I'm with, they're introducing their own arbitration masters. So if you really are serious about wanting to get into the arena and you feel you need some background, you can study. But there's no formal qualification. You need to be reasoned, you need to be independent, you need to be impartial, you need to have an open mind. You need to have patience. You need to juggle a lot of personalities, because as an arbitrator you're juggling your fellow arbitrators who might not agree. You're juggling lots of counsel, often the clients. So you need to have a lot of patience, and there's a lot of kind of juggling that's going on, and you're sitting through long hearings with lots and lots of evidence that's being presented. It's not easy.
No, I think, but it's good, because whoever is listening to that, you'd like to understand what is this process, or who want to become an arbitrator. It's good to hear from you that what sort of qualification or what sort of personality is more to do with self-personality or self-skills to be a successful arbitrator. Now, before we wind up, one of the things, because you're an arbitrating firm, you're as your organization. So do you play a role, like, of course, the main thing about conflict is how to avoid a conflict, right? So do you play a role while organizations like businesses or construction companies and all, when they make the contract itself, do you play a service role in that, or you only come?
We can, and we always encourage. It's funny because when, not only for the construction companies, because you often have to follow a standard contract when you're doing a construction contract under FIDIC, right? That's mandated. But whenever you're choosing your dispute resolution mechanism, so the corporate teams in law firms or in-house corporates, they often look at the clause to do with jurisdiction and governing laws just to kind of cut and paste, we'll get it from anywhere. It's so important to get it right, because you can have this multi-million contract, it goes wrong. And if you haven't had that contract drafted properly, you don't know where you're starting and what you're doing. I've seen clauses which are, if there's a dispute between the parties, the KSA court have jurisdiction, but if that doesn't work in 30 days, then you can bring it to Dubai under arbitration. It doesn't say which institution, and then go to Dubai courts, and you're like, where do I start? I've got a problem. Do I go to court? Do I go to arbitration? What's the governing law? What's the language? It's really important to draft that arbitration clause or the a general governing law and jurisdiction clause really properly. And unless you're in the game, you won't know. And when you're dealing with a transaction, you're not bothered about the exit. And that's the problem with contract lawyers sometimes. I always say a good contract lawyer caters for the divorce as well as the marriage. When we're getting into business, everybody's happy and we want to put all the terms. We're not really worrying about our notice or how we're going to get out. But it's very important that for both parties' protection to agree in the event of a dispute, in the event one wants to leave, how's it done, and to get it done properly. So we absolutely do get involved in the actual drafting, and it's more for a preventative measure. A well-drafted clause can save you a lot of time, headache and money in the future. I'm all about be proactive rather than reactive, because you can otherwise learn a very expensive lesson if you've got a beautifully worded contract with a very bad jurisdiction clause, which leaves you, absolutely exposed to money, time, and inconvenience.
I think thanks a lot, Sarah. I think this is something which I've been also telling from my experience. Always you said, even if you get into a small business as a partnership or anything, we always look at the good picture of we are going to become whatever. But the exit clause is something which people don't, and that's the most difficult part. And you never know, it can happen in the next 1 month or it can happen after 5 years, depending upon. I think that's very important, and that's one advantage. I always say that it might be a little expensive, a small amount which you'll pay a while before getting into a contract to, come to people like you to get a view, because you saw multiple cases, you saw some of the cases why you lost because of certain points were not mentioned, and then that adding those clauses into the contract will save, as I told you, can be a multi-million.
Again, it's the proactive approach as opposed to reactive, preventative measures. And get your foundations correct. It's so important in anything you do in business, especially multi-million contracts. Spend that extra little bit on ensuring that it kind of, is fit for purpose.
I think that extra bit, a lot of people try to save, and then later on they pay 10 times, 20 times more than that, or even they lose their business because of that.
A lot more, yeah.
Thanks a lot, Sarah. It's wonderful talking to you.
And
I'm first time having somebody from a legal side on arbitration side, and it's very important that everybody should understand a lot of different professions available in the world. And thanks a lot for your time. I know you're extremely busy for coming and sharing this information.
It's been a pleasure.
And looking forward to meet you sometime soon. Thank you.
Absolutely. And thank you very much, and thank you for having us here.
Thank you. Thanks a lot.